All right, well, it is 10 o'clock, and so we can go ahead and get started. Welcome, everyone, and thank you for joining us virtually this morning for what we hope will be an informative and helpful overview of the COVID-19 Tenant Relief Act. My name is Paige Rusa, and I am the Rent Program's Deputy Director, and Staff Attorney Palomar Sanchez will be conducting this morning's presentation. But before we get started, I wanted to share a bit of logistical information. This workshop and presentation, the slides have been posted on the website at richmondrent.org/workshops for your reference. So if you want to access the slides after or follow along with us on your own computer, you can access the slides on the website. And I also wanted to let folks know that this webinar is being recorded, and we will post the recording on the workshops page on our website next week so that you can access this presentation in the future or share it with folks who aren't able to attend this morning. For those of you who frequent our workshops, we are going to be handling the question and answer period a little differently today, and I'll let Palomar explain further. So without any further delay, I'd like to introduce Palomar Sanchez.
Thank you, Paige. Welcome everybody to the Richmond Rent Program Community Workshop webinar, Understanding the COVID-19 Tenant Relief Act of 2020, which is a part of AB 3088. Let's go ahead and get started. So first of all, I want to give a quick notice. This presentation is a broad overview of a recently passed state law. This is less than 3 months old, so it's very recent. The California legislature passed this law, and the Richmond Rent Program has no authority regarding its requirements, applicability, or enforcement. These issues may only be decided by a court of proper jurisdiction. Secondly, this presentation is not intended to act as legal advice. If you require legal advice, you should contact an attorney. Finally, this presentation, including the question and answer sessions, is to provide general information only. Any questions regarding fact-specific situations should be addressed at another time by contacting the Richmond Rent Program at 510-234-7368 or by sending an email to rent@ci.richmond.ca.us. And answers to fact-specific or hypothetical questions will not be provided a response during this presentation. Quick reminder, this presentation is regarding the main contents of the COVID-19 Tenant Relief Act of 2020 and a few associated laws within AB 3088 only. The entirety of AB 3088, when you print it out or put in a PDF, it's around 50 pages long. So I can't discuss and go over the entirety of AB 3088. So if you have specific questions about other, sections of AB 3088, as I said earlier, you can email us and we can set up an appointment to talk. But again, as a reminder, this is simply only about the COVID-19 Tenant Relief Act of 2020. And as Paige alluded to earlier, regarding the question and answer period, so given the complicated nature of the COVID-19 Tenant Relief Act of 2020, and in order to provide the most clarity on the content of this presentation, a brief question and answer period will follow each slide. So there will be no final question and answer period after the end of the final slide of this presentation. If you have any questions, please type them in following each slide. So again, as a reminder, there's going to be no Q&A session after the final slide of this presentation. If you have a question regarding a specific slide, we're going to allow a window for you to type in your question, and then we're going to move on to the next slide. Now, should any participant require further or more specific information, they may contact the Richmond Rent Program during normal business hours at 510-234-7368 or by sending an email to rent@ci.richmond.ca.us. All right, so an overview of AB 3088. Now, what is the purpose of this bill? Now, some of this is directly from the actual law as they wrote it down, as the legislature explained it. So Millions of Californians are unexpectedly and through no fault of their own facing new public health requirements and unable to work and cover many basic expenses, creating tremendous uncertainty for California tenants, small landlords, and homeowners. The bill aims to stabilize the housing situation for tenants, landlords, and homeowners while addressing the impacts that the pandemic has had on housing. Stabilizing the housing situation for tenants and landlords is to the mutual benefit of both groups and will help the state address the pandemic, protect public health, and set the stage for recovery. It is therefore the intent of the legislature and the state of California to establish through statute a framework for all impacted parties to negotiate and avoid as many evictions and foreclosures as possible. The bill does not relieve tenants, homeowners, or landlords of their financial obligations, but aims to forestall massive social and public health harm by preventing unpaid rental debt from serving as a cause for eviction or foreclosure and preventing negative credit reports as a result. If there are any questions regarding this part, you can go ahead and type them in. And we'll give it about 1 minute. All right, so here now we'll just move on. And I'm sorry for the kind of start and stop of this, but that's kind of the way we're going to run this this presentation. All right, so here we're getting into more some of the meat of this law. So the components of 3088. AB 3088 makes a series of changes to various civil codes and codes of civil procedure, including content and subject matter such as mobile home parks, an anti-retaliation statute, the state anti-gouging and just cause, otherwise known as AB 1482, Homeowners Bill of Rights, the Code of Civil Procedure, specifically notice requirements, and there are a couple brand new statutes, the COVID-19 Small Landlord and Homeowner Relief Act, and as this presentation is going to cover, the COVID-19 Tenant Relief Act of 2020. We'll get into some more specifics now, or after this next one. So again, this is just this is exactly from the law. This is just to give you a kind of a snapshot of all of the laws that have been changed. The act amends like all these civil codes. It repeals and adds certain sections. It also amends, repeals, and adds sections to the Code of Civil Procedure. And so this is, again, just a snapshot of all the various laws that have been kind of either added or augmented due to AB 3088. All right, the COVID-19 Tenant Relief Act of 2020. So the COVID-19 Tenant Relief Act of 2020, after and during this presentation, I'll refer to it as the CTRA, is intended to coordinate the state's response to COVID-19 rent-related evictions, permit the courts enough time to adjust the backlog of cases, provide tenants a clear, consistent path of obtaining protection from eviction when they cannot pay rent due to a COVID-19 related issue, and to provide landlords with basic certainty on when they can collect the rent debt owed, and creates a process whereby it's easier for landlords to access the courts to seek the debts owed. And we'll get into some more of the specifics regarding that in later slides. And until otherwise stated, all of the following slides are in reference to the COVID-19 Tenant Relief Act of 2020. Applicable sections are located at the bottom of each slide. So I tried to research the exact sections that I'll be discussing. So if you're like wondering where does this come from, what's the code, you'll look at the bottom and you'll see exactly the, in most cases, it's going to be the code of civil procedure. In some cases, it's civil code. So that if you have a question, you want to look it up, you can just, basically copy and paste that specific section and look it up online. Are there any questions regarding this particular slide? We'll give it about 1 minute. All right, hearing none, we will go to the next slide. All right, so what does the Act do? The Act modifies, again, this is the CTRA, modifies and or creates the following areas to achieve its goal. It amends summons and complaints, specifically in the context of an unlawful detainer. It creates a notice of right to be provided to tenants. It creates 2 categories of debt, which we'll be kind of going into further in a few slides. It amends the notice of termination of tenancy for non-payment of rent. It creates a declaration of COVID-19 financial distress. It amends unlawful detainer motions. It amends UD, and when I say UD, that's just short for unlawful detainer. It amends UD records. It prohibits certain types of evictions in certain circumstances. And it amends small claims court actions and limitations specifically for landlords in the context of rental debt owed. We can, if there's any questions regarding that, again, like I said, we'll go into some of the specifics of, kind of most of these categories in the following slides, but I'll give it about a minute. About 30 seconds.
It looks like we do have one question that popped up. The question is, what's the 2 kinds of debt?
Good question. And we do have a specific slide on that particular question. I will get into that specific question when we talk about the definitions of the 2 kinds of debt. So just be patient and we will get to that. All right. Here we go. All right, so the CTRA, this is definitions. And again, this is an important aspect of this because throughout this presentation, I'll be referencing these periods because it's important to understand. The CTRA defines the period of which it covers. So, excuse me. So first of all, the covered, quote unquote, covered time period is the time period between March 1st of 2020 and January 31st of 2021. So again, the CTRA covers it, so it goes retroactive, 1, from March 1st of 2020, earlier this year, and then it goes into the future up until January 31st, 2021. So again, that's called the overarching period, is called the covered period. Then what it does is it splits the rental debt into two types of categories. And this is important because there are different requirements depending on if the tenant actually owes for one period versus the other. So the first period is called the protected time period. Again, this is the protected time period. So that's the time period between March 1st, 2020 and August 31st, 2020. It's just those months. Time period between March 1 and August 31. That's the protected time period. Then there's a transition time period. And this is a time period between September 1st, 2020 and January 31st, 2021. So again, if you're a tenant or you have a tenant who owed rent from any time between March 1 and August 31, the law specifically talks about the protected time period, and there are requirements for that period. Then there are different requirements. I mean, they're similar, but there's kind of, and I'll get into the differences in a bit, for the transition time period, and that is between September 1st, 2020 and January 31st, 2021. And in certain cases, tenants may have rental debt from both periods. That would mean a landlord have to comply with both types of requirements under each specific time period. And like I said, these three terms will be referenced throughout the presentation. And so you see at the bottom there, if you want to look this up and see what I'm talking about, you can always look up the Code of Civil Procedure 1179.02, which discusses these exact definitions as well as others. Any questions? We'll give it about 1 minute.
Okay, it looks like we did have a question, but do keep in mind that there is a Q&A button there at the bottom to make your questions there in the Q&A. But I'll go to this question. It says, what happens after January 2021? Is it possible that this transition time period would be extended?
I don't know. I mean, I think that's a possibility. That's up to the legislature. Theoretically, though, if this just stays as it is, then like in February rent in 2021 would not be covered by this law. So that means that it would essentially revert back to the kind of normal requirements under the law for notices of termination of tenancy for non-payment of rent. There are, however, that said, that's specifically in the context of issuing a notice of termination of tenancy, but the collection of the debt is different. And I'll get into that in a few later in the presentation, but the debt itself and an eviction are two separate matters. And that's specifically, what this law is about. It really does kind of break up the two issues. One is, can a landlord pursue an eviction? That's one issue. And then when and can the landlord seek the debt that is owed from the rental debt? So those are two separate issues. But, as it stands now, it only covers the rent from March 1st, 2020 to January 31st, 2021.
We have a couple of questions that just popped up. The next question is there any additional protections during transitional time that affects the eviction?
I'm sorry, you broke up a little bit there, Monica. Could you repeat that?
Sure. The question is there any additional protections during transitional time period that affects owner-occupied eviction?
Owner-occupied evictions. No, well, again, the CTRA doesn't talk about owner occupancy eviction. There are other laws that we may just, at the end, we're going to discuss the Contra Costa County's ordered. But again, the CTRA is only and specifically in reference to termination of tenancy for non-payment of rent. It doesn't discuss like any other type of just cause, really. It mentions that, it prohibits a few, like maybe two others, and I'll discuss that later, but it does not talk about owner move-in terminations of tenancy.
Okay, we have one more question. The question is, are tenants still required to pay 25% of the rent on both time periods?
No, and we'll get into that in a bit, but no, that's a good question. So the protected time period is different than the transition time period. The transition time period, yes, you do have to, in addition to other requirements, the tenant is also required to pay at least 25% of the rent that is owed by January 31st, 2021 to avoid an eviction. But again, I'll go into a little bit more into that in a later slide. Are there any other questions?
No.
Okay. All right. So we'll move on. All right. So the notice of rights. So this is an important aspect, and it's kind of odd, right? Because this time period is already passed, but still, it's important to understand. On or before September 30th, 2020, landlords must provide tenants who owe rent between the periods of March 1, 2020 and August 31st, 2020, with a written notice in 12-point font that explains the tenant's rights under the CTRA. This notice must recite verbatim language provided in state law, in the CTRA. And when I say verbatim, that means exact language. If you mess up the language, it's not considered enforceable, or it's unlikely to be considered enforceable in court. This notice is separate and distinct from the notice of termination of tenancy. So in fact, you have to send an informational notice as well as the notice of termination of tenancy. And then I'll talk about the declaration in a second. But again, this notice is separate from the notice of termination of tenancy. Failure to provide this notice invalidates any subsequent notice that is served during the period, that's a bit of a typo, of March 1, 2020 through August 31st, 2020, which is called the protected time period. If you have specific questions regarding this notice or how to move forward with an unlawful detainer, specifically for the protected time period, you should consult with an attorney. We'll give about 1 minute for questions.
Okay, so we have a question, and it says, do we need to provide this notice to those who owe rent from October to January?
No. I mean, so the law specifically says that this is particularly for the protected time period. It's kind of written oddly if you actually read it. I think what they were intending to do is to say, well, if the tenant has any rent owed from the protected time period, then they have to serve this notice. And it says, and there's a section that says basically like, if you hadn't served it, then you can serve it concurrently with a notice. But that notice had to have been issued prior to September or on or before September 30th, 2020. But it actually doesn't, it's kind of oddly written, but it doesn't really specifically say that this notice has to be provided for the transition period. But to be 100%, you should just look at the law to determine. And if you have a question, you should definitely ask an attorney as far as like, what is the proper process?
Okay, we have a couple questions. The next one is there any recourse if the notice was not timely provided to tenants?
That's a good question. I don't know the answer to that. I surmise that, as I said earlier, there is a section that talks about, concurrent with a termination of a tenancy for the protected time period. And whether or not, you can argue that in front of a judge and they can accept it, that's up to the courts. You'd have to explain to the judge, why you were unable to provide that informational notice. And, there are certain circumstances, and we'll get into this in a little bit, where tenants or landlords or any claimant can say, well, I made a mistake. I didn't do this because of mistake or I just didn't know. But whether or not that is sufficient for you to move forward with an unlawful detainer when you haven't issued that notice, that's up to a judge. I don't know. And so that is, as I said at the last point, you should ask an attorney whether or not, you can proceed with an unlawful detainer had you not issued this informational notice.
Okay, next question is, what is the remedy for failure to provide a pre-9/30 notice? How can this be corrected? Does this have the effect of prohibiting landlords from access to the courts?
It doesn't prohibit access. It's just that it may prohibit you from, actually prevailing on the unlawful detainer. I don't know how a court will kind of analyze the situation. I mean, the truth is, as I said earlier, the CTRA is extremely young. It's brand new. And so I surmise that judges will, give some leeway to people who said, well, I didn't, know about this law and I didn't provide that notice, but I did give it to them after. But ultimately, that's up to a judge, whether or not they, will allow you to proceed with your unlawful detainer is 100% up to the courts. And I just don't know whether or not they'll allow you to do that.
Okay, the next question we have is, can we find a sample of this notice somewhere?
Yes, so I was gonna say that at the very last slide, but all of the forms that I'm gonna be discussing today, including the notice of rights, the actual law, a fact sheet on the law, the forms, including the declaration form for both protected and transition time period, we have links on the Richmond Rent Program website. And so if you have, if you want to look at those forms, go to our website, and on the front page, there's a bunch of links kind of in the middle of the page where you can access all of these forms.
Okay, one more question. If the landlord failed to give me that notice, would this allow me not to pay the rent?
So not necessarily. I mean, again, this is specific to unlawful detainers, right? And so it may invalidate the notice and prevent the landlord from proceeding with the unlawful detainer. But there are additional requirements for a tenant, which I'll be discussing very soon, in order to not pay the full rent. And again, the law distinguishes two types of time periods. One is for the protected time period, so that's March 1 through August 31 of this year. And then the transition time period, which is September 1 through January 31 of next year. And again, the requirements for a tenant are different depending on which period of rental debt you owe. So I'll be discussing the specifics about what a tenant needs to do and how to comply with the CTRA.
Okay, that's the last question we have right now.
Okay. All right. So this is for notices of termination of tenancies for non-payment of rent. So here's kind of a very meaty section of this law. So the following applies only to residential notices of termination of tenancy for non-payment of rent served any time between March 1, 2020 and January 31, 2021. So this is the covered period. First of all, this is a big difference. Any termination of tenancy for non-payment of rent must be a 15-day notice, excluding weekends and judicial holidays. This is a huge difference from the previous requirements under the law. It used to be 3 days. Now it's 15 days excluding weekends and holidays. So essentially it's like 3 weeks. So again, it's a 15-day notice. If a landlord tries to issue a notice for termination of tenancy for non-payment of rent, that's like 3 days, that's an ineffective notice. It's void. So again, the landlord has to give a 15-day notice. And actually I've been, asked these questions, like sometimes tenants, they'll know they can't pay the rent. They'll send them the declaration, and then the landlord will still give them a 15-day notice. Well, it is required by law, right? The landlord if they ever want to pursue an eviction, they have to give this 15-day notice. It also must contain an unsigned copy of a declaration of COVID-19 related financial distress with verbatim, there's that word again, verbatim language provided by the state. And this is under Code of Civil Procedure 1179.02. So again, in addition to the 15-day notice, they also have to provide a copy of an unsigned declaration of COVID-19 related financial distress. And again, verbatim language. You cannot write your own. You cannot, try to summarize it. It has to be the exact language provided by the state, or else it's void. And at the very least, the notice must be in the same language that the lease was negotiated in. So for example, if you entered into a lease in Spanish, oral or verbal, then you have to provide the notice in Spanish. Same thing is true with other languages. And in fact, the links that we have on our website, they provide these forms in a myriad of different languages. I think it's at least like 5 languages. The notice must specify the amount owed and apportion it by month based on the day it became due. And again, it must contain specific verbatim language from the CTRA. For notices that seek rent owed during the protected period, the language comes from California Code of Civil Procedure 1179.03, subsection B4. For notices that seek rent during the transition period, the language comes from California Code of Civil Procedure 1179.03 C4. And I'll explain the differences in a second. But for now, are there any questions regarding this slide? It looks like someone raised their hand. As a reminder, if you have a question, just you can type it into the Q&A section.
We do have one question that popped up. It says, if they owed rent from March to September, do we have to have a separate 15-day notice for rent owed from October to current?
Yeah, but it's actually, remember, the CTR divides the 2 types of debt categories. One is for March 1 to August 31, and the next is from September 1 to January 31. So it is a different notice, and I'll explain why in a second. But basically, yes, you do have to give a different notice. The main reason is because any rent owed from in the transition period, so that's September 1 on to January 31st, 2021, there are specific language saying that not only does the tenant have to send back the declaration, but they also have to pay at least 25% of the rent that is due by January 31st, 2021. So it is a different notice.
Okay, and we have another question here. It says, where can I get this new information printed?
So as I said earlier, so all of this information, including a links to the actual law, which is very long, but still, we do have it. The links to the forms mentioned in this presentation in various languages, a fact sheet regarding the CTRA are all available on our website. And so you can bring them up and then you can print them from your computer.
Okay, that's the last question.
Okay. Okay, so notices of termination of tenancy for non-payment of rent continued. What happens if a landlord's notice does not comply with any of these requirements? That means that the landlord's notice is defective. Again, I said earlier that, you know, a lot of this stuff is verbatim. Like there's no question that if your notice is not exactly as the law states, it's going to be defective and you're likely going to lose in court. So if you reach the UD stage, and UD again means unlawful detainer, the case may be dismissed, and depending on your written lease, a landlord may owe attorney's fees. This is an important aspect, right? Because if you're, you know, a lot of form standard leases have what's called an attorney fee provision, where it says that if either party needs to, you know, seek, go to court to enforce any part of this agreement, then the prevailing party will be entitled to reasonable attorney's fees. And so if you go to court trying to, you know, evict the tenant and you lose because you didn't provide the, you know, the verbatim language required by the CTRA, if the tenant has an attorney, the landlord's going to be responsible to pay for the tenant's attorney's fees. That's an important aspect. And just as an added fact, sometimes I see leases which have a one-way attorney fee provision. In general, those are not, under California Civil Code 1717, that's unenforceable. Sometimes they say, like, if, you know, landlord has to go to court to evict or enforce this lease, tenant will be responsible for the landlord's attorney's fees. Unfortunately, the law says there's no such thing as that specific code says there's really no such thing as a one-way attorney fee provision. And so if you say that, that means it's actually a two-way provision. So if that is, you know, something you are concerned about, just check your lease. If it's not there, or you have an oral lease agreement, then there's no attorney fee provision. And finally, the notice requirement is also retroactive and applies during the covered period. So again, these notices all have to comply if there's any rent in the past going up to March 1st. So it is retroactive, which is an interesting aspect of this law. Any questions on this? Give it about 30 more seconds. All right, hearing none, we'll move on. All right, so notice of termination of tenancy for non-payment of rent continued. What if a landlord serves a notice based on rent owed that overlaps, and this is kind of that question earlier, between the protected and the transition time period? So the landlord must then serve two separate and distinct notices. Each notice must comply with the separate rules governing the protected period and the transition period. The language in each applicable notice is verbatim and issued by the state. Again, there's that word, verbatim. The law is very clear on that you have to use verbatim language. Failure to use such language renders the notice void. And again, the specific section is at the bottom of it. Code of Civil Procedure 1179.03E. Any questions? We'll give it about 1 minute.
Okay, we have one question. The question is, if you have given one notice for both periods, can you go back and give them the proper notice?
Can you go back and give them the proper notice? I'm not totally sure. I mean, so yeah, I mean, you have to give two separate notices. You cannot give one notice. So it just depends on what that first notice was. Like, was the notice for the protected period? Then that doesn't cover the transition period. If you gave it for the transition period, it doesn't cover the protected period. So you, again, those notices will be unlikely to, move forward in court. And so you'd have to reissue those notices to the tenant in order for them to to allege that they're enforceable. Now, whether or not they are in fact enforceable and whether or not you can actually prevail on an unlawful detainer based on those notices, that's up to a judge in court.
Okay. Next question is, do we have to serve a notice every month that they owe rent? And they gave an example. Let's say they owed rent for November and we served them the notice and they don't pay again in December. Do we have to serve them another notice to include December rent? Yes.
So just similar, like as if a tenant, like prior to the CTRA, prior to this pandemic, if a tenant didn't pay rent in November and then they didn't pay in December, you couldn't issue a notice in November anticipating that they wouldn't pay in December because you don't know, right? But in order to move forward with an unlawful detainer based on a particular month, you have to give a notice for that particular month. It's not like you can give a general notice and say, well, this notice applies just in the future. That's just not how it works. You have to, again, the law says you have to state, how much they owe for what month, very specific. So you have to give separate notices for each one. And again, I mean, that's up to you. Like, let's just say you give a notice in November and then they don't pay in December. And theoretically, you can move forward with a UD on the November one because you properly noticed that. But you couldn't say, well, I also want to evict them for December's rent. Well, you didn't provide the notice. So then that would not be part of your UD.
Okay, that's the last question.
Okay. All right. The declaration of COVID-19 related financial distress. This is an important one. How does a tenant take advantage of the protections under state law, under the CTRA? If the tenant only owes debt during the protected time period, the tenant need only return the signed declaration to the landlord prior to the expiration of the 15-day notice of termination of tenancy for the state law protections to attach. Again, for the protected time period. So if landlord issues a notice for any of those months from March 1 to August 31, all the tenant has to do is return that signed declaration within the 15 days before it expires. Once returned, the landlord can never evict the tenant for the debt owed during the protected time period. And again, this harkens back to what I was saying earlier, is that there's two issues. One is the eviction and two is the debt. And so you have to distinguish those two facts. And that's exactly what the law does. Once returned, once that declaration is returned, excuse me, for the protected time period, the landlord can never evict that tenant for the debt owed during the protected time period. Now, excuse me, if the tenant owes rental debt during the transition time period, is different, right? The tenant must return the signed declaration to the landlord prior to the expiration of the 15-day notice of termination of tenancy. And again, this is a big one. And by January 31st, 2021, pay 25% of the total amount of rent owed. So in an example, if the tenant didn't pay October rent, the landlord would send a 15-day notice. Then the tenant returns the declaration, but that's not all. It's not over. Now that tenant has until January 31st of 2021 to pay 25% of October's rent. If they do that, right, and that's the last bullet point here, if the tenant does these two things, the tenant can never be evicted for the rental debt owed during the transition time period. So again, very clear that the law says they can never in the future be evicted if they follow these guidelines. And again, the specific codes of civil procedure are there at the bottom for reference. Any questions? Give it about 1 minute.
Okay, we have a question. It says, is there a time cutoff for serving a 15-day notice termination of tenancy? So can a notice for October be served in December?
It's a good question. I think so. But if you issue a notice and then accept rent after that, that notice is now void. But that said, and I think you should talk to an attorney about these kind of specific questions, but I think you can serve a notice. You don't have to serve it that month, because maybe you gave them a little window to, catch up or something like that. It doesn't render your notice void necessarily. But I think you should talk to an attorney about those kind of specific questions. But like I said, I don't think so.
Okay, there's no more questions.
Okay. All right. Returning the declaration. How does a tenant return the declaration? And the law specifically outlines these ways. So one is just through the U.S. mail. And tenants are encouraged to ensure that they can track it, and it is to the address provided in the notice. They can also do it in person. They can also do it via email if the notice of termination of tenancy received from the landlord provides for an email address. And also, they can be delivered through the same method the tenant delivers rent, if possible. Tenants are encouraged to document the sending of the declaration by any means possible, right? Because that's an important aspect. In order to avail yourselves of the protections under the CTRA, you have to comply with these particular requirements. And so that means proof, right? That can be a myriad of different ways. You can do certified mail, you can have a proof of service, you can hire a processor. There's all kinds of ways. You can take a picture. It doesn't matter. The point is, you have to document it just to kind of protect yourself. And similarly, landlords are encouraged to document the sending of any of these applicable notices and declaration forms. Again, certified mail, process server, proof of service. There are specific ways to serve a termination of tenancy that's outlined in the Code of Civil Procedure 1162. So again, there are various ways, but any way you choose, make sure you document it. Now, if a tenant failed to return the declaration within the expiration of the 15-day notice, and assuming the landlord has filed an unlawful detainer, tenants may still submit their declaration to the court if the court finds that the tenant's failure to submit the declaration was the result of mistake, inadvertence, surprise, or excusable neglect, then the court will dismiss the case. So again, essentially tenants get two bites of the apple. They have this 15-day notice period to return the declaration, but then they also can say, oh, I didn't, it was a mistake on my part. I didn't know. And then they could submit it directly to the court, but then they would have to argue and tell the judge, this is why I couldn't submit my declaration within that 15-day notice. And if the court agrees with the tenant, then the court will likely dismiss the case. Again, there is a distinction here though, like for the covered period the protected period versus the transition period. Because all they're required to do for the protected period is just return that declaration. Now I'll get into some of the specifics if the notice is regarding the transition period. Basically, because they still have to pay that 25%, the court is going to allow them like 5 days to do that. So I'll get into the specifics on that in a little bit. But and again, the specific codes are there at the bottom. Are there any questions regarding this slide? We'll give about 1 minute. All right. Hearing none, we'll move on. All right. Now, this is a different specific section talking about high income tenants. This is not, generally speaking, normal, most tenants. This is going to be high income tenants. So, and I'll explain what this kind of means. Can a landlord ask the tenant for proof that they have been impacted by COVID-19? Generally, no. Like sometimes landlord asks us, oh, well, my tenant is claiming COVID-19, that has impacted them, but I want to ask them for proof. No, you can't ask that. But there is one exception. And the exception is where the landlord already knows that a tenant is a high income tenant. High income tenant is a tenant, and this is defined by the law, with an annual household income of 130% of the median income as published by the Department of Housing and Community Development. And in no way can it be less than $100,000. So the household income must be above $100,000 per year. This exception only applies if the landlord already has proof of income in the landlord's possession before the service of the notice. So you cannot, inquire, well, I think you're, making tons of money, and I'm going to ask your employer to, how much you're making. You cannot do that. You already have to know that. And so, for example, if you know that, your tenant is like a CEO of like some tech company or something, it's very likely they're making quite a ton of money, of Google or something. But besides that, you cannot inquire. And so that's the next point. Can a landlord ask the tenant or third party person, meaning that the employer, a government agency, a financial institution, or any other source for financial information to either prove or disprove that the tenant is or is not a high-income tenant? Absolutely not. In fact, this is expressly prohibited by the CTRA. So there's an emphasis that the landlord has to already have this information, independent evidence that this person is a high-income tenant. And again, this is under Code of Civil Procedure 1179.02.5. Any questions on this? And we'll have another, I think we have one more slide on high income, yeah. We'll give about 1 minute. About 30 seconds. We'll have one more slide on high income tenants, at least one more.
We have a question. The question says, is the tenant required to provide proof at any point?
No, only if you already know that they're a high income tenant, right? If they are not, if you do not have independent evidence that the tenant is a high income tenant, they're not required to provide proof. The only things they're required to provide is one, the declaration within the 15-day notice, or the declaration and pay that 25%, but they are not required to provide proof generally, no.
Okay, no more open questions.
Okay, moving on. All right, what happens if the landlord has independent proof that a tenant is a high income tenant? So this is when you already know. The landlord must include verbatim, again, there's that word, verbatim state law language. This is provided in the CTRA in their 15-day notice, which explains the tenant's additional obligation as a high income tenant and the need to submit additional documentation demonstrating a COVID-19 impact. And this is under Code of Civil Procedure 1179.02.5 B, subsection B2B. Failure to include this statement will result in a tenant not having to comply with the additional documentation request. So again, you have to give them this language. If you don't, then they don't have to provide the proof. The tenant has the duration of the 15-day notice of termination of tenancy to return the declaration and submit additional documentation to demonstrate a COVID-19 financial impact. The additional documentation is listed in the state law, specifically under 1179.02.5, subsection A to A through G. But generally, any form of objectively verifiable documentation that demonstrates the COVID-19 related impact is enough to satisfy this requirement, including a letter from an employer. Now, what happens if the landlord claims that a tenant is a high income tenant, but does not have independent proof? If the matter goes to a UD, again, that's an unlawful detainer, the landlord must plead and prove as much. If the landlord cannot, then there is a unilateral attorney fee provision for the tenant. Now, that's an interesting point. You know, earlier I was saying there's no such thing as a unilateral attorney fee provision, but this new law does carve out one. And it says, well, you know, if arguing that the tenant's high income, but then you don't have the proof, and then the case gets dismissed, that tenant won, and now you will be responsible for paying the tenant's attorney's fees if they have them. Any questions on this? We'll give it about 1 minute. All right, hearing none, move on. All right, unlawful detainers. So what happens if the tenant does not submit the declaration, and specifically the declaration within that time period? Then the landlord may proceed with the filing of the UD, of the unlawful detainer. Now, is there anything the tenant can do? Now, this is kind of what I was referencing earlier. So upon receiving the unlawful detainer, the tenant may attach as part of their answer the declaration. So again, part of the unlawful detainers is that once the tenant is served with the papers for the lawsuit, they have to file an answer. Now, with that answer, they can then file a declaration because they didn't previously within the 15-day notice. So once the court receives the declaration, the court must set a noticed hearing. Now, at that hearing, the court must determine whether the failure to submit the documentation was a result of a mistake, inadvertence, surprise, or excusable neglect. If the court finds one of the aforementioned bases, the court must do either of the following. If the UD seeks debt only during the protected time period, the court must dismiss the case. So again, if they find that the failure to provide the declaration within the 15-day notice was a result of mistake, inadvertent, surprise, or excusable neglect, and it was only for the protected time period, that case will be dismissed. If the UD is filed before February 1st, 2021 and seeks debt during the transition time period, the court must dismiss the case. Now, if the UD is filed after February 1, 2021 and seeks debt during the transition time period, the court must give the tenant 5 days to pay 25% of the rent. And if paid, then they dismiss the case. So again, the tenant has this almost like a second bite of the apple. They will say, well, look, you are not only did you, okay, sure, you didn't file the declaration, that's fine. But now you only have 5 days to pay that 25%. And if you do that and you can prove it in court, then the judge is likely to dismiss that case. But if the tenant doesn't pay that 25%, then the court may render a decision in favor of the landlord. Any questions on this? And the reason that it says if the UD is filed before February 1, 2021 and seeks debt during the transition time period, the court must dismiss the case is because the tenant is, by the express declaration of this law, they have until January 31st to pay that 25%. And so essentially the landlord's too early. And so they filed it too early so that the court is not going to allow it to proceed. Bit about 1 minute. All right, hearing none, we'll move on. All right, summons and complaint. Some of this is a little odd because this is already passed, but still, as it relates to summons and complaint, and again, this is specifically in the context of an unlawful detainer, these will not be issued prior to October 5th, 2020, if any portion of the UD is related to rent. So basically, the law is saying you cannot file a UD before the 5th of October. Obviously, that's passed now, so it's not really that much of an issue. Likewise, default judgments will not be issued prior to October 5th, 2020 if any portion of default is based on rent. Landlords, now this is an important part, landlords must file a supplemental cover sheet together with the summons and complaint. The cover sheet information, like what specifically you need to put in your cover sheet, is found in the Code of Civil Procedure 1179.01.5 subsection C2. This is kind of the reason that they're asking this is because they want to categorize unlawful detainers based on non-payment of rent really quickly. They want to see, okay, is this case about rental debt? Yes, then they're going to put it over here. No, they're going to kind of deal with the rest of the different cases. But again, landlords have to supply this supplemental cover sheet in addition to the regular summons and complaint. And that's required under the law. And landlords may obtain a summons and complaint or seek a default judgment on other grounds besides non-payment of rent. Again, this law, the CTRA, is specifically in reference to non-payment of rent. Other, bases for an unlawful detainer are not rarely covered under this law. And so it's more or less like the normal kind of process, but the CTRA is specifically in the context of non-payment of rent. Any questions on this? We'll give it about 1 minute. All right, moving on. All right, unlawful detainer records. Will filing a UD, again, that's unlawful detainer, during the protected time period hurt the tenant's credit record? And in fact, I think that should say covered time period. I'm sorry about that. Unlikely. UDs that are based on non-payment of rent, non-payment of COVID-19 rent are restricted, except in very limited circumstances. The exceptions can be found in Code of Civil Procedure 1161.2 and 1161.2.5, such as if you're a party to the action, including the party's attorney, to a person who provides the clerk with the names of at least one plaintiff and one defendant, to a resident of the premises for which the COVID-19 rental debt is owed, who provides the clerk with the name of one of the parties or the case number and shows proof of residency, to a person by order of the court, which may be granted ex parte on a showing of good cause. And there are a few others. So does the state law prohibit any other evictions? And I think this is one of the questions earlier. Yes, it actually prohibits substantial rehabilitation of the unit. And generally, that's usually a temporary eviction, especially under the rich rent ordinance, and also demolition, unless, again, so it prohibits these types of evictions unless those evictions are necessary to maintain compliance with applicable law governing the habitability of residential rental units. So when you talk about law governing the habitability of residential rental units, sorry, there's a second period there. You're talking about like Civil Code 1941.1, Health and Safety Code 17920.3, and also the implied warranty of habitability. But again, those are exceptions that you should probably discuss with an attorney prior to moving forward with that type of action, because in general, they are prohibited, but there's an exception. So you'd have to argue that exception in court. Any questions on this? We'll give it about 1 minute.
We have one question here. It says, does that include owner move-in eviction in regards to the slide?
No. So remember, this is all about unlawful detainers based on non-payment of rent. That's it. So the law does not talk about other types really of evictions besides the two at the bottom, the substantial rehabilitation and demolition, but nowhere does it mention anything about owner move-in or other causes of action for an unlawful detainer. Any other questions?
No other questions. Nope.
Okay. All right. So this is getting into a kind of different section of one of the laws kind of changed under AB 3088, and that is specifically the Small Landlord and Homeowner Relief Act. So this is in regards to small claims court and this law. So again, earlier I said there's two issues regarding this law. One is eviction, and two is the rental debt itself. Remember, nothing about this law forgives the tenant just indefinitely for rental debt that is owed. And so this section is specifically about, landlords seeking that debt, not eviction, but the debt itself, which is a clear distinction in the law. So beginning March 1st, 2021, landlords may pursue COVID-19 related debt in small claims court. There are no limits to how much can be sought and how many different cases may be brought. This is an interesting point, right? Because prior to the passage of the CTRA and the Small Landlord and Homeowner Relief Act, there were limitations on, one, how much you could sue in small claims court, and two, how many cases you could file in any calendar year. Previously, the rules were generally it was like $5,000 or $10,000 in small claims court. Now that limit is gone if it's related to rental debt under COVID-19. So they stopped that limit. So now there is no limit in small claims court for a landlord who's pursuing COVID-19 rental debt. Similarly, the law previously was that you could only file one small claims court, I think it was one small claims court case per calendar year above $2,500. They changed that and they said that's no longer applicable. There are no limits. You can file as many cases as you want above 2,500 or below. It doesn't matter. You can just file as many as you want. Again, in the context of COVID-19 related debt. Now, what about Richmond's grace period? So Richmond had its own order. It was the Richmond moratorium on eviction, and it actually allowed for a grace period for tenants to pay back any rent that was owed while that law was in existence. Now, Richmond's grace period began September 30th, 2020, and ends September 30th, 2021. So this means that landlords cannot seek a COVID-19 related debt, which was incurred during the period of the Richmond order in small claims until September 30th of 2021. So again, they cannot seek that debt if that debt was covered by the Richmond order. However, if it wasn't covered, and remember the Richmond order only covered rent up to September 30th. So let's say it was October, November's rent, that's different. They don't have to wait till September 30th, 2021. They can actually start to seek that rental debt as early as March 1st, 2021. Now, what about the 25% requirement and how does that work with the grace period? So this is interesting. That is a separate and distinct requirement as it is a requirement under the CTRA. Richmond's grace period will only protect tenants from immediate small claims action. That's it, not eviction. to avail oneself of the protections of the CTRA, the 25% must be paid in accordance with the state law. So again, you have this distinction between rental debt and eviction. And that's a key point. They're not mixed together. They are separate and distinct. And so if a tenant wants to prevent the eviction part, then they have to follow the CTRA, pay the 25%, return the declaration. But if they want to, but that's different than the debt, right? If they were covered under the Richmond order, then the debt itself is different, and the landlord would have to wait until after September 30th, 2021 to seek that debt. But again, this is still confusing. That doesn't apply for rent after September 30th of this year. So if the tenant owes for October, November, December, then the earliest the landlord can go after that debt would be March 1st, 2021. And like I said earlier, there's no limit now. Landlords can go to town. They can go as many cases and as much as they want in small claims court. Any questions on this? And again, the Code of Civil Procedure 116.223 at the bottom, that's the law, or the section of the law to look at regarding this slide. We'll give it about 1 minute. All right, moving on. All right, this is an important part. This is a different section of AB 3088. This is civil code in regards to an anti-retaliation statute under Civil Code 1942.5. So AB 3088 amended part of an existing anti-retaliatory statute. The law added a new section specifically in reference to COVID-19 rental debt. The new section states, it is also unlawful for a lessor, meaning, the landlord or a master tenant or anybody with the authority to rent and collect rent, rent the unit out and collect rent, to bring an action for unlawful detainer based on a cause of action other than non-payment of COVID-19 rental debt, as defined in section 1179.02 of the Code of Civil Procedure, for the purpose of retaliating against a lessee, which is the tenant, because the lessee has a COVID-19 rental debt. So again, what that's saying is you cannot bring an unlawful detainer based on a different cause of action simply because the tenant has COVID-19 rental debt. Landlords may not be receiving that debt, and then they're like, they want to retaliate against a tenant due to that fact. And they'll say, well, I want to do something else. You breached the lease or something like that. And if that is found out to be in retaliation, specifically because they just have a COVID-19 rental debt, then that landlord will be, in violation of this statute. And it says any lessor or agent of the lessor, a management company or something like that, who violates this section shall be liable to the lessee in a civil action for 1, actual damages, 2, punitive damages, and that's at least $100 up to $2,000 per retaliatory act, and 3, reasonable attorney's fees for any prevailing party if it's requested in court. So again, if a tenant files an action against the landlord and says, you tried to evict me simply because I had this rental debt, then, and the judge agrees, then the landlord would be liable for, or the lessor or agent of the lessor would be liable for all of these particular damages potentially. Any questions on this? We'll give it about 1 minute. All right, hearing none. All right, now this is separate and apart from the CGRA, state law, or anything that I've been talking about. So we're going to talk just very briefly about the Contra Costa County Urgency Ordinance 2020-26. So the city of Richmond did not renew the Richmond moratorium on eviction, and thus the Richmond order expired as of September 30th, 2020. But the Contra Costa County did pass what's called the Urgency Ordinance 2020-26. The Richmond City Attorney's Office has indicated that the county's order will apply in the city of Richmond. The county's ordinance does the following. It prohibits no-fault evictions. So even if you're not in Richmond, it does prohibit no-fault evictions, just like, you know, if you're in Contra Costa County, not in Richmond, but in Contra Costa County, and then the landlord just issues a termination of tenancy, you know, for no stated reason, that's actually prohibited by law. But there are exceptions. So exceptions are for owner move-in evictions, for health and safety reasons, or and the Ellis Act, which is the removal from the rental market. So again, there are specific exceptions to that prohibition on no-fault evictions. And then it also prohibits evictions where the tenant allows an unauthorized occupant to live in the dwelling unit if the occupant is a member of the tenant's immediate family living in the dwelling unit and the occupant moved in as a result of the COVID-19 pandemic. Now, this is an interesting point of this ordinance. I've actually had a question about that. I've talked to a landlord, I believe it was, and they were telling me that they believe that the tenant had moved in some family. And, you know, could they pursue an eviction based on the breach of the lease agreement, all that stuff. And I cautioned them and I reminded them of this ordinance and said, well, look, you know, it actually prohibits an eviction if the tenant allows some unauthorized person to live there, if that person or people is a member of the tenant's immediate family. And unfortunately, the ordinance doesn't really specify what that means. And also they're, you know, so one, they have to be immediate family, and two, they have to be living there as a result of the COVID-19 pandemic. Now, if those two things are true, then you cannot evict that tenant due to the unauthorized occupant living in that dwelling unit. Yeah, so are there any questions on this? We'll give it about 1 minute.
We have a question here. Question asks, when does this ordinance expire?
That's a good question. I think it's up until January 31st of next year. But if you want to look at the specifics, I suggest you just look up the Contra Costa County website and they'll have a link to this urgency ordinance. But I'm pretty sure it's till January 31st.
There are no other questions.
Okay. All right. Now, again, according to the Richmond City Attorney's Office, the county's ordinance, again, there's a Contra Costa County Urgency Ordinance 2026, not the rent programs. It prohibits rent increases on residential real property through January 31st, 2021. And again, according to the Richmond City Attorney's Office, this includes rent-controlled units in the city of Richmond. But there are exceptions on this prohibition on rent increases. So one is units that fall under Costa-Hawkins, that's the Costa-Hawkins Rental Housing Act, units exempted from state law rent control, and then rent increases where one or more scheduled rent increases occur pursuant to a written rental agreement that was entered into before March 16th, 2020. If you have a particular question on whether or not you can actually proceed with a rent increase notice, one, you can contact the Contra Costa County. Two, you can contact the rent program. Or three, you may want to speak to an attorney. And as a reminder, this is the Contra Costa County's order, not the rent program. So although the rent program may assist in answering general questions regarding the county's ordinance, you may want to contact the county for more specific questions. And like I said, if you can talk to an attorney, that's probably the best. So you may want to research that too. Any questions on that? Give it about 1 minute. All right. All right, so that was the last slide. I want to thank everybody for attending this. You can always reach the Richmond Rent Program at 510-234-RENT or 7368. You can also email us at rent@ci.richmond.ca.us or visit us at www.richmondrent.org. And as a final note, again, as I said kind of earlier in the presentation, our website has a COVID-19 Tenant Relief Act fact sheet in English and Spanish and links to the applicable forms mentioned during this presentation in various languages, as well as links to the actual law. And if you have specific questions, regarding your specific situation, definitely feel free to call us or email us. We can set up an appointment to speak, or we can respond to you through email. But we do encourage you to reach out to us if you have any further questions. And I'll hand it back over to Paige.
Great, thanks, Palomar. And we just have one question that got entered in the chat that I'm wondering if you can answer. And
Sure.
that is, will the rent increase schedule be every January now instead of every September?
Oh, no. So the Richmond Rent Ordinance, as I said earlier, is independent. It's not the county's ordinance. So our ordinance has been unaffected. In general, the initial time that landlords can generally take an annual general adjustment is September 1st of every year. Obviously, that was a bit augmented due to the pandemic and like this ordinance and all of that. But in general, that remains unchanged.
Thanks, Palomar. So as Palomar mentioned, please contact us if you have further questions or want to talk one-on-one with one of our housing counselors. And this presentation and the recording will be posted on our website at richmondrent.org/workshops. Thank you so much for spending time with us this morning, and we hope you have a great rest of your day.
Take care, everybody.